next case is State versus Meinke. Each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. And we are just a couple minutes early. Are we okay to proceed?
I think so.
Thank you.
Your Honors, my name is Zachary Simon. I represent the appellant. I would like to reserve 5 minutes at the end.
Thank you.
Your Honors, this case is boiled down to the proposition that a defendant has a right to have all the necessary elements of the offense instructed to the jury, and before the jury can find him guilty beyond a reasonable doubt. In 2013, as cited in my brief, the Supreme Court of Ohio decided States versus Smith that noted that the service of a protection order in the offense of violating a protection order is a necessary element of the offense of violating a protection order. At the trial, the defendant's counsel requested specifically on page 243 and 244 of the transcript that that element be instructed to the jury, and the judge decided that since that request was not done in writing, she would not instruct the jury on that element. However, it is attached to and cited in my brief and attached as exhibit as Appendix B, the Ohio jury instructions 519.27 was amended 1 month prior to the commencement of this trial to specifically include the issue of service of the protection order. And so when the matter went to the jury was unclear about how they were to go determine the issue of service. And that kind of dovetails into my second assignment of error, which is sufficiency. All the references to service of the protection order were made by hearsay, and I understand that my friend on the other side is saying that those are hearsay arguments that, and 90% of them were not objected to at the trial. However, the jury had the right to go hear the instruction and determine those statements and weigh them to determine whether they found Mr. Meinke guilty beyond a reasonable doubt. Because it was objected to, the State versus Smith analysis of looking at it as plain error isn't necessary, because actually it isn't necessary because it's been objected to, so therefore it's preserved error. And on top of that, the Hoover versus Garfield from the Sixth Circuit Court of Appeals, when dealing with the issue of trespass in a burglary, says that leaving out an element of a crime is always material and never harmless. So with regard to this matter, failing to instruct the jury with regard to service of the protection order is not harmless error. It was preserved by the defendant at trial, specifically requested, specifically citing to this case, and it was not instructed to the jury, and the jury was not given the opportunity to weigh the evidence of all the elements of the offense of violating protection order. And if this court has no further questions, I would sit down. Thank you.
Thank you.
Good morning. May it please the court. My name is Matt Mishak, and I represent the state of Ohio in this matter. Your Honors, the position of the state is that the trial court's instruction was proper, and in the alternative, if it wasn't proper, that it was harmless error that wouldn't have affected the result of the case. Criminal Rule 52A governs the analysis of a preserved error, and any error which does not affect the substantial rights shall be disregarded under State versus Fisher. Criminal Rule 52A provides 2 requirements in the analysis. The first is, do we have a deviation from a legal rule? The second involves a specific analysis of the court record to determine whether it affected the substantial rights of the defendant. And And that's been interpreted to mean, does the error affect a prejudice upon the defendant? Does it affect the outcome of the trial? Now, as to the first prong of the 52A analysis, the due process clause of the 14th Amendment does require the state to prove every fact necessary to get a conviction beyond a reasonable doubt for which the defendant is in charge. Now, the legislature's recitation of the statute is usually dispositive. The unusual thing here is in State versus Smith, the Ohio Supreme Court ruled that to sustain a conviction for a violation of protection order, the state must establish beyond a reasonable doubt that it served the defendant with the order before the alleged violation. Now, it's important to note that Smith does not specifically require a jury instruction on the matter, and the OGI instructions proffered by defense counsel is certainly not binding on this court. It's a function of the Ohio Judicial Conference. I believe that State versus Smith, in a way, is a case of limited application. The state does not dispute that the trial court did not instruct the jury on the specific element of service of the protection order, but a failure of a court to instruct on an element of case is not necessarily dispositive and does not require reversal of a conviction. Only by reviewing the record can the court address the probable impact of such an effect, that there is a manifest carriage of injustice. The law, as well as the facts in the case, should govern this analysis. Now, Smith reached a different result based on very different facts. In Smith, it was undisputed that the defendant was not served with the protection order prior to being charged with violating it. Here, the opposite is true. Here, it is undisputed that Meinke was served with the protection order on April 18th of 2014. The victim, Don Gibson, testified unequivocally that he was served with it. Both Officers Weber and Officers Halverson both independently testified that he was served on April 18th. There was a certified copy of the civil protection order submitted to the court. And thus, the state's position is that the failure to instruct on this particular element, if the court does find that it is necessary to instruct, is harmless error. And if you look at the Hoover case, it does quote U.S. King, talking about undisputed evidence, and U.S. versus Valdez, talking about clearly established elements. Additionally, I think that this element of the state's position, at least, is that this element is technical, it is a procedural element, and it doesn't, it's not like an element like in Adams that affects a specific intent or culpability. Also, the state's position is this element could have been presumed by the jury. The jury in the instruction was instructed on recklessly, that they must find that Meinke recklessly violated the terms of the protection order. Recklessly was defined as perversely disregarding a known risk. This instruction would allow the jury to presume the element of service from a predicate facts and distinguish it from cases that would completely prevent the jury from considering this element.
How does that let them, what you just read, how does that let them presume it got served?
It would allow them to...
It says you can't recklessly violate the terms of the order. It said there's a certified copy of the order in, but how does that presume that he got served with it before the conduct occurred?
Well, the court did define recklessly as a known risk.
It doesn't matter what the definition of reckless is. How does that presume that, you said there's a certified copy of the order admitted into evidence. Is there a certified copy of the return of service?
There's not a certified copy of the return of service in evidence.
So as far as the jury knows, the only reason this guy may have been served is because the officer testified he was served.
Well, there was testimony from the victim, Don Gibson, that he was served. He did make late admissions in his text messages that he had been served, that he'd known that he had previously been charged. There was 56 phone calls made from this defendant to the victim, Don Gibson. The jury had assurances enough from Don Gibson that he had been served with this protection order. But in addition, there was also the testimony of Officer Weber, who was training an officer on the dating question, but did verify through the law enforcement automated dating system and through dispatch and the serving agency that he was indeed served. Officer Halverson additionally verified through the lead system and also verified with dispatch that the signed copy of the service was on file with the police department.
Why would the state object to an instruction that said the state needs to prove beyond a reasonable doubt that this guy got served with the order before this conduct occurred? Why would you object to it? Not you, but why would anybody object?
I don't know if the state did objected to that, or if the trial judge ruled before the state had to wait in. I know that the trial judge did not consider the motion because the proposed jury instruction was not submitted in writing. So I'm not sure if the state had a chance to object or not, Your Honor. And to respond to your question, beyond that language, there would be no other language for the jury to make that presumption, Your Honor, if I didn't fully answer that before. I don't believe that this is what was described in Hoover as a structural error. I don't think it involved a deprivation of a constitutional right. And even if it did, there's the option for the court to consider that it did not affect the constitutional right beyond a reasonable doubt. Some examples that were talked about in Hoover was a coerced confession, complete denial of counsel, or denial of impartial judges was something that could never be looked at in a harmless error analysis. I don't think this service element is of that same idea, same category. As far as the assignment error sufficiency, this court standard is to view this in light most favorable to the prosecution, and whether evidence, if submitted, if believed, would convince the average mind beyond a reasonable doubt. Again, there was a certified copy of the CPO. There's unequivocal testimony from the victim, Heather Gibson, that he was served. In addition to the other evidence I talked about, Gibson testified that on the date Meinke was served, she began receiving incessant text messages from him. This is certainly circumstantial evidence that Meinke had been served on this date. There's also, as I mentioned, the unequivocal testimony from Officers Weber and Halverson that Meinke was served. These sources are there's going to the leads automatic data system by contacting the serving agencies. It's the state's position that these sources do carry with them a certain degree of reliability and credibility. Meinke did not object to the hearsay testimony of these officers at trial, and this should subject this to a plain error analysis. Defense doesn't raise plain error with this trial court, with this court, and this court has refused to sua sponte insert a plain error analysis in cases in the past, and I did cite State versus Griffin for that proposition. As far as allied offenses of similar import, the final State versus Johnson states that 2 or more dissimilar offenses committed at different times or with separate ill will are not allied offenses of similar import. There were multiple contacts on May 4th and 5th. Some were imminently threatening, others were simply a contact. Therefore, Meinke should be able to be charged and convicted of all these crimes. Your Honors, if there's no further questions for me at this time, I would reserve my remaining time.
Well, you don't get any other time. But
Oh, I'm sorry, excuse me.
That's all right. I'm just saying.
I don't come here often.
That's all right. As the appellee, you just get your 15 minutes. If you want to, you have 5 minutes left if you want to raise any other issues or make any other arguments.
No, I would
Just forego
sorry,
it. Okay,
Thank you.
thank you. No problem.
May it please the court. Just as I said briefly, Your Honors, the issue with the sufficiency of the evidence, and the only reason why that would be really relevant is that there was no way for the jury to weigh whether or not they received it, whereas my friend on the other side says that the leads database and the uncontroverted testimony of the victim that said they told me he was served on April 18th was uncontroverted. The jury had an obligation to go assess those statements and determine whether that established beyond a reasonable doubt that he did actually receive a copy of the protection order. Because Smith says service means actually receiving a copy, not being aware that it had been granted. but having actually received a copy. And there was no evidence other than that unobjected to hearsay that would establish that. Thank you, Your Honors.
Thank you. Court will take the matter under advisement. I do appreciate, and the court appreciates the arguments presented today, and you will receive a copy of our written opinion, and also we release it on the website.
Thank you.